So restaurants who are facing closures or potentially laying off either temporarily or maybe even permanently a large number of employees have to keep in mind that there are state and federal laws governing notice that you may have to give. The Federal WARN Act and the California version, CalWARN, both require employers to give notice to employees and state and local governments, usually 60 days notice before you make certain business closures or mass layoffs. Now, there can be substantial civil penalties up to $500 a day under CalWARN for failure to give notice to the government, and then pay in lieu for failure to give timely notice to the employees. So it's critical to really be aware of the requirements, and the analysis on whether you are a covered employer or whether it's a covered event can be tricky. So we're going to give you kind of a good overview, but really if you have any concern or doubt about whether you qualify under WARN or CalWARN, it's critical to get legal counsel on your specific situation. Now, I know there's been a lot of coverage, and I believe Matt mentioned that the governor took some action with respect to CalWARN. I want to warn you, we're going to discuss it in a little bit, but the governor did not completely suspend CalWARN. There's still certain obligations that you have to meet. So be aware of that, and we will get into that as we discuss CalWARN. First, the Federal WARN Act, there's 3 steps you need to consider. First, are you a qualifying employer? And you would be a qualifying employer if you have 100 or more full-time employees. Full-time employees being they work at least 20 hours a week and they've been employed for at least 6 months of the last 12 years. Or if you have 100 or more employees and combined they work a total of at least 4,000 non-overtime hours per week. So that's step 1. If you meet either of those criteria, you would be a covered employer. The next step you then have to consider is the action you're taking a plant closing or a mass layoff? And then step 3 is, do any exceptions apply? So going to step 2, what is a plant closing? A plant closing is a permanent or temporary shutdown of a single site of employment that results in employment loss for 50 full-time employees during a 30-day period. Now, the employment loss under federal WARN is defined as 1, termination, except for cause or voluntary retirement. So some sort of termination that's not the employee's choice or fault. But an employment loss can also be a layoff that exceeds 6 months. So if you have a situation where you're laying your employees off for 6 months, that would also count as an employment loss. And then finally, a 50% reduction in hours for each month for an employee for 6 months. So if you take an employee and you cut their time in half or cut their time by more than half for 6 months, that may also trigger WARN. Now, thankfully, under both federal WARN and CalWARN, the sale of the business does not trigger employment loss. So the other way that you could have trigger federal WARN is if there's a mass layoff, and that would be employment loss at a single site of employment that is either 500 full-time employees or it's 50 full-time employees, and that those employees constitute 1/3 of the workforce at that site. Either of those situations would trigger a mass layoff requirement under federal WARN. Now, there are exceptions to the federal WARN 60-day notice. If you're actively seeking capital or business and you can't make the notice because that would interfere with getting that capital or that business, that is an excuse for not giving a 60-day notice. The 2 others that are, I think, most applicable here are if the business circumstances were not reasonably foreseeable or there's a natural disaster, those also excuse the notice requirements to varying extent. I think the strong argument that coronavirus situation would qualify under both of those. But even with FedWARN, you also have to consider CalWARN, whether it applies. And it's the same 3-step process but the steps are slightly different. The first step is, again, instead of are you a covered employer, is your facility a covered establishment? And your facility is a covered establishment if you've employed 75 or more persons over the past 12 months. That's full-time and part-time, current and former. If you're a covered establishment, you then have to consider step 2, did you order either a mass layoff or termination or relocation? And step 3, do any exceptions apply? So a termination under Cal Warren would be the cessation or substantial cessation of your commercial operations at a covered establishment. If that occurs, that would trigger Cal Warren. The relocation, probably not relevant here, but if you move more than 100 miles, your business operations, that would be a relocation. And then a mass layoff is separation from the position of work, lack of work or funds, 50 or more employees during a 30-day period. These employees, to count towards the 50, have to have been employed at least 6 months in the last 12 months. But it also applies to even temporary layoffs. And there's a case where, a company told the workers that they were going to be laid off for about 4 weeks and gave them a return date. The court still found that that was a mass layoff triggering Cal Warren requirement. So really, restaurants want to consider and keep in mind that even if you're telling your employees that it's only going to be a short layoff, that you still have to consider whether that triggers Cal Warren. Now, Cal Warren has a physical calamity exception for the notice requirement. Not a lot of case law as to what that means, certainly no case law now as to whether a pandemic would qualify. I think there's good arguments for, but I could also see some strong arguments against it. As we mentioned, as Matt mentioned, Governor Newsom did sign an executive order restricting some or easing some of the requirements of Cal Warren. And what essentially it did was it didn't eliminate the notice requirement, but it excuses and shortens the notice requirement so you don't have to give the 60-day notice if you meet the 4 conditions set forth in the executive order. So the first condition is you actually have to give the notice. You have to comply with the notice requirements of Cal Warren. The notice has to be given as soon as practicable, and the notice needs to include a brief statement on why you didn't give the full 60-day notice. The termination or relocation or mass layoff has to have been caused by COVID-19 related business circumstances that were not reasonably foreseeable. And the executive order contains a specific statement related to unemployment insurance that if you give the notice after the executive order was signed, you need to include that notice in that statement in your notice. The Labor Workforce Development Agency is supposed to provide guidance by today on further guidance on implementing this executive order, so stay tuned. If you do have a qualifying event under Cal Warren, who do you have to give notice to? There's notice that you have to give to the affected employees, but also you have to notify the Employment Development Department, a local workforce investment board, and then the chief elected official of the city and county where the covered establishment is located. And the requirements, the notice that you have to give differs for the employees versus the government, but that's all laid out in the Warren regulations.